Good evening. It's 7:30 p.m. Friday, October 4th, 2019. This is Chris Bacon coming to you from 108 Marshall Street. This is the basement. Again, a lot of people are probably going, "What the heck's his problem, eh?" Hopefully not, because hopefully you're getting it. Anyway, what I wanted to do is point out where this is coming from too, and put it back in the laps of those people that are responsible or should be responsible, being the City of Waterloo, the region of Waterloo, the province of Ontario, and especially the landlord. Landlord-tenant board, being a quasi-judicial tribunal, again, doesn't have to follow any rules or laws, I guess, other than as they make it up as they go along, especially when it comes to accessibility. Again, all these people are misunderstanding because I have PTSD, I have other issues which they're all aware of. Yes, I could write things down, but I shouldn't have to, because for me to do it, it's like going to after being repeatedly traumatized again too and again. This experience is just one in a list of many. Again, this is why it shows a pattern of behavior which has been exhibited across all platforms, and it doesn't matter which party you vote for. The pattern of behavior is revealed to be what's underlying the problems with the law in Canada and anywhere else in a British Commonwealth, I would assume. Anyway, again, this is, I didn't orchestrate any of this stuff. We got caught in the middle of it again. Anyway, let's get to the point. I don't want to be too long-winded in this. So there's going to be a couple camera angle changes. Right now I'm going to show you where I'm going with this. So what you're looking at now, if I can get it on camera, is this is a printout of a story that was published in the Waterloo Region Record, December 12, 2018, by Jeff Outhit, entitled "Waterloo Sticks with Controversial Rental Licensing Fee." I'm going to try and hold that steady. It says, now just before I start with that, maybe you can follow along. So what I'm going to do is I'm going to tilt this up here a bit, and we'll get the iPad on here. Oh, sorry. I'll try and do this here. So what I did was link to the record license story, so by Jeff Outhit, published in, and we're going to publish this link on the actual, in the notes section of this video. So just look down below, and what you do is you click on the link, and it takes you to therecord.com and the story right at therecord.com. So as you can see, that is the story, the same one that I'm about to read. Okay. Oh, Mr. Trudeau. Good thing we have the sound off. You don't want to hear any more lies, eh? Anyway, not giving him a free commercial. Anyway, nothing's free in this country, especially the people and tenants especially. Anyway, so again, here it is. So go ahead and use the link, follow along with us. In the meantime, I'm going to utilize this version because that way you can follow along with me. Okay, so it says, Andrew McCallum, president of the Waterloo Regional Apartment Management Association, asked Waterloo Council on Monday to axe the rental bylaw and fee that applies to landlords in smaller buildings. Then Matthew McCarty, Waterloo Region Record file photo. So it begins. Waterloo, landlord Nathan Forster pays $700 every year to Waterloo and feels he gets nothing in return. That's the licensing fee the city charges him to help ensure the duplex he rents is safe. Forster argues the fee duplicates provincial safety regulations, costs him money that otherwise would be used to improve his rental units, and he charges that it is partly misspent by City Hall to enforce other bylaws. There doesn't seem to be an effort for fairness to landlords, Forrester told Waterloo Council on Monday. And again, just to put this in context, from December 12th, 2018. But that's just before 2019. That's actually 7 days before they found out about this landlord and gave him a notice. Anyway, so continuing on, Landlords often get painted with a thick brush. We're typically deemed as slumlords or as affluent in some way, but I assure you it's not the case. After hearing criticism, council voted to maintain its controversial rental fee for 10 more years. Quote, it allows us to take action rather than waiting for the provincial regulation to take place, Mayor Dave Jaworsky said. It allows us to help students and other renters out earlier. That is a direct quote from Mayor Dave Jaworsky. Again, it allows us to take action rather than waiting for the provincial regulation to take place. Mayor Dave Jaworsky said, it allows us to help students and other renters out earlier. Landlords decry the fee as an unfair tax grab that collectively strips them of $1.3 million a year. People love to hate landlords, said Andrew McCallum, president of the Waterloo Region Apartment Management Association. Now, I said see continued because it's actually because of my printing, it's over here. So you can see it's actually the same thing. People love to hate landlords, and that's where it ends up here. So that's what's crossed out. So it continues, and you can see McCallum asked council to cancel the rental bylaw. So because it's cut off at the bottom of that one, we'll continue here. McCallum asked council to cancel the rental bylaw because he said it duplicates provincial regulations. There are already those safety checks. They already exist in the province of Ontario. Not according to what's happening here. And you'll see the evidence later in my conversation with Shamir Maida when he first contacted me on the phone. Anyway, it surprised him. Continuing on, it surprised him to hear that council uses the rental bylaw to protect the human rights of tenants and learn that fees are waived if landlords provide subsidized housing through a regional program. Again, I want to reiterate, it is published. It surprised him to hear that council uses the rental bylaw to protect the human rights of tenants and learn that the fees are waived if landlords provide subsidized housing through a regional program. Then it goes on to show the graphs, and they're actually continued over here, so I actually did larger ones. I think they're at the back here. It shows the graphs, but that's in the story. It's just to show that the whole story was here. So anyway, back to the text. Waterloo is the only local city that licenses landlords who must provide their unit or prove their units are safe. Landlords pay an annual fee of $287 on average. The rental bylaw in place since 2012 applies to low-rise homes, duplexes, and townhouses, but not apartments buildings, which the city argues are typically safe. The city licensed 3,680 units last year and expects to sell 5,564 rental licenses by 2029. Council intends to freeze fees until then, balancing them slightly to decrease most fees and increase others. The city says rental licensing helped resolve more than 700 fire code violations and more than 1,200 electrical defects while securing 350 bylaw convictions between 2012 and 2016. Students at Wilfrid Laurier University have praised rental licensing, saying it improves students' lives and reduces tenant complaints. The undergraduate student government has asked the city to extend licensing to high-rise. There you go. Reduces tenant complaints. The undergraduate student government has asked the city to extend licensing to high-rise buildings. Landlords argue the fee boosts Waterloo rents. They point to a 2017 court ruling that allowed a local landlord to increase rents to help pay for the, quote, extraordinary increase in municipal taxes and charges, end quote. Quote, the rental bylaw targets and taxes good, well-intentioned people, McCallum said, citing tenants to whom the costs are downloaded and providers who are impacted by its bureaucratic nature. This is a very important paragraph in closing. Waterloo courted controversy by regulating rental housing. The city had to fend off a court challenge and tweak its regulations to resolve discrimination concerns raised by the Ontario Human Rights Commission. J. Outhit at therecord.com, Twitter at OuthitRecord. Okay. So, again, it says that in December 2012, when it was published, December 12, 2012, that, 2018, December 12, 2018, in this article, it states, Waterloo courted controversy by regulating rental housing. The city had to fend off court challenge and tweak its regulations to resolve discrimination concerns raised by the Ontario Human Rights Commission. As I said, it applies to low-rise homes, duplexes, and townhomes, but not to apartment buildings, which the city argues are typically safe. That's not quite accurate, and we're going to cover that because I'm about to read you what the actual rental license bylaw states. But again, here it stated, it surprised him to hear the council uses the rental bylaw to protect the human rights of tenants, and learn that fees are waived if landlords provide subsidized housing through a regional program. Well, you be the judge. Are our human rights being protected here? Are any of our rights being protected here? But the biggest one is Mayor Dave Jaworsky. It allows us to take action rather than waiting for provincial regulation to take place. Mayor Dave Jaworsky said. It allows us to help the students and other renters out earlier. So again, here it is, and again, as I said, there it is online. So go look at it online. I will scroll through it to show you that it's the same story. I don't want to vote Mr. Trudeau, who has a problem telling the truth, though. Mr. Trudeau has trouble telling the truth, though, as does every other politician in Canada. But we'll get to that. Anyway, so there's the graphs, as I said, all stretched out. And that's the whole thing. And again, there you go, have your say. Oh, have your say. How do you feel about Waterloo's rental license rental fee? I'm for it, but landlords' concerns must be addressed. I'm against the city's rental fee. Or I'm not sure. Gee, that's really good choices. So that's what I mean by padding the file. So there's no other. Right? So they... yeah, okay. Skewing the results, are we? So you're for it. You're for it, but landlords' concerns must be addressed. So what about tenants' concerns? I'm against the city's rental fee, and I'm not sure. What about tenants' concerns? They don't even put it in. How's that? That's interesting. That's today. Anyway, I don't want to go on with this. Sorry. Just back and forth all the time, but I'm trying to do a presentation here, and my brain injury and all that. So right now, what I'm going to do is, I think it's time we read the bylaw itself. So, it's really good. Again, we're going to put the link. The link is in the description part of the pages. Okay. Sorry. It's in the description. It's going to be in the description part of the page. So we're going to the. Oh, let's see. I've got it down here. Okay. So I'm going to turn this around again at the screen. We'll move it up a little bit. So again, it's waterloo.ca, link to bylaw. Direct link to the City of Waterloo website, last updated October 2nd, 2019, so that was like 2 days ago. So again, you click the link. No, that's okay, program camp. Anyway, and it brings you up to the actual website. So this is waterloo.ca, as you can see at the top, waterloo.ca. Residential rental licenses, it says, low-rise residential rental units require an annual license to ensure safe accommodations. Full details are in the rental licensing bylaw. Let's click on that, and we come up with the actual bylaw. Now it states, this bylaw version is provided for convenience only and is relied on at your own risk for accuracy and reliability. Please refer to the original and any amending or replacement bylaws. Okay, but this is the most recent one that they published. Office consolidation to August 22nd, 2016, last amended by bylaw number 2016044, August 22nd, 2016. So I guess we got to look up 2016-044. Okay, so Corporation of the City of Waterloo, bylaw 2011-047, being a bylaw to provide for the licensing, regulating, and governing of the business of residential rental units in the City of Waterloo. Whereas Section 151, Subsection 1 of the Municipal Act 2001, Standard Ordinance 2001, Chapter 25 is amended, parentheses, the quote, Municipal Act 2001, end quote, end parentheses, states that a municipality may provide for a system of licenses with respect to a business and may, A, prohibit the carrying on or engaging in the business without a license, B, refuse to grant a license or to revoke or suspend a license, C, to impose conditions as a requirement of obtaining, continuing to hold, or renewing a license, D, impose special conditions on a business in a class that have not been imposed on all of the businesses in that class in order to obtain, continue to hold, or renew a license. E, impose conditions, including special conditions, as a requirement of continuing to hold a license at any time during the term of the license. F, license, regulate, or govern real and personal property used for the business and the persons carrying it on or engaged in it. And G, require a person subject to such conditions as a municipality considers appropriate to pay an administrative penalty if the municipality is satisfied that the person has failed to comply with any part of a system of licenses established by the municipality. And whereas the Council for the Corporation of the City of Waterloo considers it necessary and desirable to regulate residential rental units in order to A, protect the health and safety and rights, A, protect the health and safety and human rights of the persons residing in rental units. B, ensure that certain essentials are provided in residential rental units such as plumbing, heating, and water. And C, protect the residential amenity, character, and stability of residential areas. So let's just talk about that a minute. So what that is that's the purpose of the Act. What they're saying is that this is quoted from the Municipal Act, which states what gives them the right and what they have the right to do, which is the first part. Then because of that, Council Corporation of the City of Waterloo considers it necessary and desirable to regulate residential rental units in order to accomplish these three things. Again, number one being protect the health and safety and human rights of the persons residing in rental units is the prime directive. Ensure that certain essentials are provided to residential rental units such as plumbing, heating, water, and protect the residential amenity, character, and stability of residential areas. Again, you be the judge. Is that what they're doing here? Are they protecting our rights? Are they protecting the rights of any tenants? Are they protecting the future tenants if we get evicted from here? Because there's an outstanding order of 80 days plus and counting, which they're all just denying to do, and they're required by law to do it. Anyway, you be the judge. It's all right here. This is in real time. You be the judge. So, carrying on. Now, therefore, and please bear with us. It only takes a bit of time to go through this, so we'll have it explained. It's only going to take that much time. I hope you bear with us and see what we're talking about, because this is a public safety issue of a grave nature and needs to be addressed. We're hoping that we can get some assistance to help us with our situation, but it's more important that the situation be corrected. So anyway, continuing on. Now, and thank you for your patience. Now, therefore, the Council of the Corporation of the City of Waterloo enacts as follows. 1. Definitions. For the purpose of this bylaw, the following terms shall have the corresponding meaning set out below. Adult means person 18 years of age or older. Section 1 definitions added adult by way of bylaw 2014-008, January 27, 2014. Apartment building means building including masonette. A, containing 4 or more dwelling units. B, where the dwelling units are horizontally separated. And C, where each dwelling unit has access to a common interior corridor system with a common exit at grade level. Bedroom means a room or area in a dwelling unit used, designed, equipped, or intended for sleeping. Building means A structure occupying an area greater than 10 square meters consisting of a wall, roof, and floor, or any of them, or any structural system serving function thereof, including all plumbing works, fixtures, and service systems appurtenant thereto. Which means a building with multiple apartments in it is the building, exactly as I described in the video. B, a structure occupying an area of 10 square meters or less that contains plumbing, including the plumbing appurtenant thereto. Or C, structures designed in or designated in the building code. Okay, building code means Ontario Regulation 350/06 as amended. Chief building official means the chief building official for the city appointed or constituted under Section 3 or 4 of the Building Code Act 1992. Standard Ordinance 1992, Chapter 23 as amended, parentheses, the quote, Building Code Act 1992, end parentheses, end quote, end parentheses. Chief Fire Prevention Officer means the Chief Fire Prevention Officer for the city or his or her designates. Chief of Police means the Chief of the Waterloo Regional Police Service or his or her designates. City means a corporation of the City of Waterloo. College means a college established under the Ontario College of Applied Arts and Technology Act 2002, Standard Ordinance 2002, Chapter 8, Schedule F as amended. Council means Council of the City. Director means the Director of Municipal Enforcement Services for the city or his or her designates. Dwelling unit means unit, whether in whole or in part, that A, consists of a self-contained set of rooms located in a building, B, is used or is intended to be used as a residence, and C, contains a kitchen and a bathroom facilities. Fire chief means the fire chief means the fire chief for the city or his or her designates. General manager of development services means general manager of development services for the city. Gross floor area means the area of a floor measured to the inside of all outside walls, enclosing any floor or part of a floor that complies with all applicable law for the shelter, accommodation, or enclosure of persons, above which is clear height of at least 2 meters, or for any floor below grade, and above which is clear height of at least 1 meter for any floor above grade, excluding the area of any garage, porch, veranda, sunroom, or stairwell. Group home means a residence licensed or funded under a federal or provincial statute for the accommodation of 3 to 10 persons, exclusive of staff, living under supervised in a single housing unit who by reason of their emotional, mental, social, or physical condition or legal status require a group living arrangement for their well-being. Human Rights Code means the Human Rights Code, RSO 1990, Chapter H19 as amended. Kitchen means a room or area in a dwelling unit used, designed, equipped, or intended to contain cooking facilities, including any 2 or more of a refrigerator, stove, and sink. Licensing Appeal Tribunal means tribunal established by Section 6 of this bylaw. Local contact means an agent or representative of an owner who does not reside in the regional municipality of Waterloo who is responsible for managing or addressing issues in relation to the owner's rental unit. Lot means parcel of land which is A, shown as a lot or block on a registered plan or subdivision, or B, described in a single transfer deed of land that is registered in the Land Registry Office or the Land Titles Office for the Land Registry Division of Waterloo. Medical Officer of Health means the medical officer of health for the regional municipality of Waterloo or his or her designates. Municipal Law Enforcement Officer means an individual appointed by the Council of the City pursuant to Section 15 of the Police Services Act, RSO 1990, Chapter P15 as amended. Owner includes a person who alone or with others owns premises containing a rental unit. Owner occupied means occupied by persons holding at least 50% of the title to the property as identified in the Ministry of Government and Consumer Services Parcel Register. So even if a person is an owner and they don't own 50% of the property and they occupy the property, that is not considered owner-occupied. They must have at least 50% of the title in their domain in order to do that. Which means that if that is under 50%, and even if one of the owners is occupying it, it's under 50%, they are required to obtain all permits the same as anyone else. And if it's not owner-occupied, they are required to obtain all permits and do it properly as per the prescribed method. Which is what should have happened before this, and now that he's been caught, he has to do the permits as well. Anyway, that's if they hold him to it, but it looks like they're not going to. He obviously paid for the privilege not to be held accountable. Anyway,
Person means an individual, sole proprietorship, partnership, unincorporated association, organization, including a charitable organization or a corporation. Police officer means a police officer as defined by the Police Services Act, RSO 1990, Chapter P15 as amended. This is really interesting. This is the most important part. Rent includes the amount of any consideration paid or required to be paid for the right to occupy a dwelling unit, and for any services and facilities and any privilege, accommodation, or thing provided in respect of the occupancy of the rental unit. And for greater certainty, rent includes the amount of any such consideration paid or required to be paid by 1. An owner to another owner, and 2. By a shareholder of a corporation owner to the corporate owner or other owner. Rental unit means a dwelling unit offered for rent. Residential rental business means the operation of a rental unit. Tenant means a person who pays rent or is required to pay rent in return for a right to occupy a rental unit. So again, they establish you are paying for the right to occupy. This license is about the right to occupy and have the landlord allow him to actually offer it to be occupied at lawful rent. Without lawful rent, without a license, it is not allowed to be occupied. They are not allowed to cause rent to be collected. It's very clear. I guess just not to the people enforcing it. I guess the more dollar bills get in their face, they just start to get blurry vision and stuff, eh? Anyway, I don't care what the reason is. If it's by error, omission, or deliberate, does not matter. The fact that it exists is highly obstructive and is causing a lot of damage while robbing the city of proper revenue is. Anyway, back to this. University means University of Waterloo or Wilfrid Laurier University, and zoning bylaw means zoning bylaw passed by the city pursuant to Section 34 of the Planning Act, RSO 1990, Chapter P13 as amended. Then there's a footnote. Section 1, definitions, delete and replace by bylaw 2013-069, August 12, 2013. Section 1, definitions, what? Is that the whole section? It doesn't even say Section 1 definition. Okay, so which part's Section 1 definitions? Oh, there you go, Section 1 definitions. So that whole part is saying is what? Okay, so I guess we got to look up 2013-069. And let's see what that is. So I'll have to do a codicil. I'll have to do that. So we'll have to do that one later to find out what the definitions. Section 1, definitions. You know what? I gotta stop this. Okay, so took a little bit of a break. Here we are back again. Prohibitions. Now, I'm not going to read the whole thing. We're just going to go through the parts that are applicable to what's going on here. Feel free to read through the whole thing, though. It's very informative. It's only 31 pages. We're on page 5 right now. Section 2, prohibitions. And this is the most important part. 2.1, no person shall do any of the following except in accordance with a license issued under this bylaw. A, carry on a residential rental business. B, permit a person to carry on a residential rental business. C, collect rent or permit rent to be collected for a rental unit. Or D, hold themselves out as being licensed to carry on a residential rental business. This landlord did all of those things from May 2017 when we entered in the contract until June 19th, 2019 when he was finally issued a valid rental license for this property. Between 2017, because these are not transferable, so it doesn't go from one landlord to the next. They have to reapply as a new property if it's a new owner. 2017, there was one issued, but it was expired. March 31st, it expires. and it's not transferable. So again, 2017, when we rented the property, he carried on a residential rental business. He permitted himself to carry on the residential rental business. He collected rent and permitted rent to be collected for a rental unit, and he held himself out as being licensed. Now, let me point out at the very beginning it says no person. That includes any inspector, any municipal enforcement person, and especially Shane Turner. The City of Waterloo, because a corporation is deemed to be a person, have the rights of a person. Anyway, just pointing it out. So section 2.2, prohibitions again. No person shall do any of the following other than at a location for which a license has been issued under this bylaw, which there was no license issued between 2017, not a valid one for Theo Papadopoulos Commissions Worldwide, Inc., from May 2017 until June 19th, 2019. There was no valid license. So again, it states, no person shall do any of the following other than at a location for which a license has been issued under this bylaw. A, carry on a residential rental business. B, permit a person to carry on a residential rental business. Or C, hold themselves out as being licensed to carry on a residential rental business. Section 2.3, no person shall do any of the following under a name other than the name under which a license has been issued under this bylaw. And again, he did not own the license. It was in the previous owner's name, the Chavez's. 2.3, no person shall do any of the following under a name other than the name under which a license has been issued under this bylaw. A, carry on a residential rental business. B, permit a person to carry on a residential rental business. Or C, hold themselves out as being licensed to carry on a residential rental business. 2.4, no person shall do any of the following except in accordance with the provisions as set out in this bylaw. Carry on a residential rental business. B, permit a person to carry on a residential rental business. C, collect rent or permit rent to be collected for a rental unit. Or D, hold themselves out as being licensed to carry on a residential rental business. So again, it's prohibited. You must have a license. The property that you are putting out to be licensed must be, or to be rented, must be licensed. And you cannot do any of these things without, except in accordance with the provisions as set out in this bylaw, which includes all provisions. Okay? 2.5, no person shall transfer or assign a license issued under this bylaw. There you go. So a license bylaw typically, a rental license bylaw license typically expires March 31st of every year. So 2.6, this is the most important one. No person shall provide false or misleading information to the city when applying for a license under this bylaw, renewing a license, or at any other time. We have proven no less than 4 falsified, misleading, and misrepresented applications, which all 4 for these properties that he entered into, especially saying again that this property met fire code because it failed, that it meets any kind of bylaw because it failed. There is an outstanding order of over 80 days, a municipal order that says that this has failed. It also in that order says the 98B failed because it's 98B's fence. As we said, it showed. Now 98B, from what we published the other day, showed that there's no fire compliance in there since 2012. And here we have. So, yet in the application he said that it met fire code and building code regulation. He swore to it. Well, attested in a legal declaration under the Municipal Act. Anyway, again, point 2.6. No person shall provide false or misleading information to the city when applying for a license under this bylaw, renewing a license, or at any other time. 2.7. Notwithstanding any other provision in this bylaw to the contrary, a license to carry on a residential rental business shall not be required for A. That section was deleted by bylaw number 2016-044, August 22nd, 2016. But it still continues. B. A student residence operated by university or college in zone B1, I guess, or BI, under the relevant zoning bylaw. C. An apartment building. D. A group home. E. A hotel, inn, or bed and breakfast. Or F. A rental unit to which any of the following statutes or regulations apply. Homes for Special Care Act, RSO 1990, Chapter H12 is amended. That's for point 1. Point 2, the Innkeepers Act, RSO 1990, Chapter 17 is amended. 3, Long-Term Care Homes Act, 2007, Standard Ordinance 2007, Chapter 8 is amended. 4, the Retirement Homes Act, 2010, Standard Ordinance 2010, Chapter 11 as amended. And 5, the Social Housing Reform Act, 2000, so Standard Ordinance 2000, Chapter 27 as amended. G. Social housing or affordable housing that is not subject to Social Housing Reform Act 2000, Standard Ordinance 2000, Chapter 17 is amended, but which is subject to an agreement with the Regional Municipality of Waterloo and which has been approved for exemption by the Director. Licensee requirement. There should be 6 types. Anyway, the Class A, Class B, and all that goes through. Anyway, you could go and read all that stuff too, but... Okay, so let's see, what does it say? Okay, so that's classes. Well, actually, let's go through the classes. There should be 6 types of licenses to carry on residential rental business under this bylaw. Class A. Class A licenses, more particularly described in Schedule 1 of this bylaw, which are required for all rental units that are not covered by any other classes in this section. B. Class B licenses, more particularly described in Schedule 2 of this bylaw, which are required for all rental units on residential rental properties that are owner-occupied, except those rental units for which another class of license has been obtained. C. Class C licenses, more particularly described in Schedule 3 of this bylaw, which are required for all rental units with 5 or more bedrooms. Okay, that's not a Class C unless they rent every room out. If they rent every room out again, then it'd be Class C. Class D licenses, more particularly described in Schedule 4 of this bylaw, which are required for all recognized lodging houses. Class E licenses, more particularly described in Schedule 5 of this bylaw, which are required for all temporary rental units. And Class Z licenses, more particularly described in Schedule 7 of this bylaw, which are required for all rental units in buildings that contain 4 or more dwelling units where dwelling units are horizontally separated. Any person seeking, Section 3.2, any person seeking to obtain or renew a license to carry on a residential rental business shall A. Be at least 18 years of age. B. Complete an application in the form prescribed by the Director, including setting out such information and attaching such additional documentation as may be required by the Director, in which includes the information documentation outlined in Schedule 6. C. Submit the completed application to the Director. And D. Pay the applicable fee pursuant to the city's fees and charges bylaw. 3.3. Once a person has been issued a license to carry on a residential rental business under this bylaw, they shall A. At all times post a copy of the license issued to them in a conspicuous place in the rental unit as well as a floor plan. So you must have a rental license posted. Now, the funny thing is, what is a rental license? What does it look like? Okay, well, here, I'm going to show you. This is a copy of the actual residential license that he was granted for 100A Marshall Street. And this is a picture of it because, let's go over it. So it says residential licensing permit number 2019-004349 because that's the number that you see on the top of all the pages regarding the license. That becomes the license number. Now, it's interesting because it says right on this document, and again, this as it says here, at all times, so 3.3, once a person has been issued a license to carry on a residential rental business under this bylaw, they shall, A, at all times post a copy of the license issued to them in a conspicuous place in the rental unit as well as a floor plan. So much the same as motel or hotel. But as you can see, because of that, here's the license again, and it states right on the top, failure to post a permit card is an offense under the Residential Licensing Bylaw 2011-047. And you can see its municipal address is 100 Marshall Street, A, Waterloo, Ontario, Norman 2 Jack, 2 Terrence 4. Its classification is Class A, 4 bedrooms. Description, Unit A. Date issued June 19th, 2019. Expiry date June 31st, 2020. Its owner, name, occupant is 2011987 Ontario Inc. 455 Old Oak Drive, Waterloo, Ontario. Now that should state Theo Papadopoulos operating as, but local contact, they got Theo Papadopoulos 519-569-1905 CCW or CWW Inc. at Outlook.com. No special conditions, signed by Shane Turner, Director of Municipal Services. So that's what's supposed to be public, like it's supposed to be publicly displayed in the unit. Okay, the reason why we got that is actually he's never displayed it. It's still not displayed to this date. There is no floor plan displayed either. They refuse to come and look at anything that this man does or doesn't do because he's been bought the privilege, I guess. You know, and the thing is that there was one hanging up here, the one that was hanging up here when we went to rent it. But we'll get to that later. Anyway, if you are currently renting anywhere in the City of Waterloo, and it's for, what do they say, 3 stories or more, or 3 stories or less, and you're residential or student housing, doesn't matter. If you are renting in the City of Waterloo and there is not one of these posted prominently in your common area of your unit, including a residential, so I mean, even if it's just a family home, there's supposed to be one of these with a floor plan posted up in a common area of the house, and it is to remain there. That is what it says on this order, and on that license, and that's what it says here in the bylaw. At all times, post a copy of the license issued to them in a conspicuous place in the rental unit as well as a floor plan. B, when requested to do so by a municipal law enforcement officer, immediately produce a copy of their license for inspection. C, notify the director in writing within 14 days of any change to the information or documentation submitted with their application, and then the person shall, as soon as is practical, provide such updated information documentation as may be required by the director, and D, attend a single training or education session, whether online or in person, in relation to their license as required by the director. So, did he notify the director in 14 days of any change to the information, being that it wasn't accurate, such as what we found next door for the fire infractions, and even here? Again, that is sorry, I'm going to turn this off. That is a simple thing. You call Becker Fire and Safety. Very highly recommended. I've used them myself several times. Those companies exist for the sole purpose of being consultants, for the purpose of going, what is required. You pay a fee. There's usually a flat rate fee for coming out for the home call, and then whatever it costs to, like if you choose to buy your stuff from them, because I don't think you have to buy it from them, but if you choose to buy it from them, it's whatever you pay for. So you have to pay for the consultation and the visit, and then whatever you have to add to your plan. But they will provide you a written plan that shows exactly what you need. They will provide it for you. They will put it in place for you so that everything's exactly right for when you have the fire department come up. When you look at the video from before, when the fire department came, that's because they did the inspection beforehand and they were coming back without telling us that it failed. You know, again, they're kind of shoving it at us, and it took me a bit to realize, wait a minute, it failed. So again, that wasn't accurate in his application either. So there's 4 fraudulent applications here. Anyway, we've just presented the evidence of what's going on. You be the judge, okay? That's why this is court of public opinion. Anyway, we hope that we can get somebody to help us to resolve this lawfully. Anyway, I'm almost done doing this part, and let's go back to it. Sorry. So 3.4, a property on which a rental unit is situated shall be subject to only one class of license at any time. 3.41, notwithstanding section 3.4 of this bylaw, property on which a rental unit is situated may have at the same time 3.411 a Class A and a Class B license, or 3.412 Class D and a Class A and or B license. 3.5, each rental unit shall be individually licensed to carry on a residential rental business. Section 3, licensing requirements, subsection 3.1 and 3.2b, delete and replace by bylaw 2013-069, August 12, 2013. License issuance, section 4. 4.1, and this is very important too. The director shall issue or renew a license to carry on a residential business to any person who meets the requirements of this bylaw, except where? A, the past conduct of the person who applies for the license affords the director reasonable grounds to believe that the applicant has not or will not carry on the residential rental business in accordance with applicable law or with honesty and integrity. You be the judge. Did Mr. Papadopoulos and Commissions Worldwide meet that test? B, the director reasonably believes that the issuing of a license to a person might be adverse to the public interest. So you think that having an outstanding order in place that has not been satisfied yet is adverse to the public interest and safety when it kept us in danger and continues to this day. It is over 80 days in not been honored, and not even the director and them can cancel it. The only way it can be canceled is by honoring it and satisfying the order. That is what the law states, and even the director and the city is responsible to follow the law. C, the property on which the rental unit is situated is subject to an order or orders made pursuant to or by number 1, the city's property standards bylaw. So again, it says, or the Building Code Act 1992, or any regulation made under it, including the Building Code, Fire Prevention, Protection and Prevention Act 97, as amended, or by the Medical Officer of Health. D, the rental unit itself, the building in which the rental unit is situated, or the property on which the rental unit is situated is not in compliance with a zoning bylaw. Or E, the person who is applying for the license is indebted to the city by way of fines, penalties, judgments, or outstanding past due property taxes. So let's go back to that. It says, the director shall issue or renew a license to carry on residential business to any person who meets the requirements of this bylaw, except where? He did not meet A, honesty and integrity. The number C, the property on which the rental unit is situated is subject to an order. There is an order by the property standards bylaw people dated June 13th, 2019 that was supposed to be satisfied July 15th, 2019, is over 80 days overdue, which also contained infractions from the Building Code Act and the Fire Protection Act. But the Fire Protection Act was satisfied here, but they didn't even do an inspection next door. Zoning bylaw, as far as I know, is fine. But anyway, that is definitive. Shane Turner, there's the license that he is not allowed to issue if there's an outstanding order. There's an outstanding order. It says right there. And yet the privilege of this landlord, he was able to buy his way right out of this and circumvent our rights with the assistance of the city and Shane Turner. 4.3, for the purpose of section 4.1 and 4.2 of this bylaw, the term person shall include any director, officer, partner, or principal of a partnership or a corporation, or any shareholder of a corporation that holds at least 50% of the shares of that corporation. 4.4, the director may at any time when issuing or renewing a license to carry on a residential rental business impose such terms and conditions on the aforementioned license as the director considers appropriate, such as honoring the tenancy. And if the law says, oh, it's there to help the tenants, protect the rights and the human rights of the tenants, right? Again, I ask you to use your best judgment. What do you think? Am I crazy? Is Denise crazy? Should the director refuse to issue or renew a license to carry on residential rental business, or should the director impose terms and conditions on the license, the director shall provide written reasons thereafter. Unless renewed, license issued or renewed under this bylaw to carry on a residential rental business expires on the 31st day of March next following the issuance or renewal of the license. Section 4, subsection 4.6. Delete and replace by 2012-04, January 16, so that's this one. Section 4, subsection 4.2b and 3. 4.2b and 3. (4.2b) and 4.3 delete and replace by bylaw. So again, 4.2b, director may deny the issuance of a license to carry on residential rental business where the person who is applying for the license has been convicted within the past 5 years of a statutory regulatory offense in any way related to the ownership or management of residential rental properties. So they removed that and replaced that with something, and also 4.3. For purposes section 4.1 and 4.2 of this bylaw, term person shall include any director of the corporation. So that's nothing of what we said. So revocation. So, I'm not going to go into the revocation and all that because apparently he's able to do that. The point that we're trying to make here is that Shane Turner did not have the right to, or within his own bylaw, to even grant a rental license, which he obviously did on June 19th. Just to let you know, again, here I'm going to show you this as well. I'm not sure, I think I did before, but just flip this around again. This is a copy of the actual letter that was sent out to Theo Papadopoulos. You can see 2576514 Ontario Inc., Care of Commissions Worldwide Inc., 254 Anita Court, Waterloo, Ontario, Norman 2K, to Robert 4. December 19th, 2018, City of Waterloo. Now, this letter is applicable to all properties owned and or managed by Worldwide Commissions Inc. That's why they only sent one letter for more than one property. This is the letter that was sent in order to start the process when we got the letter from him in January that we were going to have some inspections because of this licensing. So, dear property owners, regarding rental housing licensing bylaw and licensed property, as a result of information received, we have identified 100B Marshall Street as being a rental property within the City of Waterloo, and as such, subject to the requirements of the rental housing licensing bylaw 2011-047. The rental housing licensing bylaw requires that all low-rise rental units obtain a license. Section 2.1 states, and again, that's a repeat of what we just read, no person shall do any of the following except in accordance with a license issued under this bylaw. A, carry on a residential rental business. B, permit a person to carry on a residential rental business. C, collect rent or permit rent to be collected for a rental unit. Or D, hold themselves out as being licensed to carry on a residential rental business. In order to apply for a license to carry on the business of a residential rental, a complete application and license fee must be submitted to the Municipal Enforcement Services at the address noted below. Detailed information regarding the application process can be obtained at www.waterloo.ca/rental or by calling 519-747-8785. Please contact the undersigned or submit a residential rental application for your property no later than January 30th, 2019. Failure to submit an application within this time frame may result in further legal action. Regards, Kristen Vandergeld, MLEO, C, CPSO, Licensing and Standards Officer, Municipal Enforcement Services. Phone 519-747-8776. Email kristen.vandergeld@waterloo.ca. So, he received this on 2018. This is applicable to all properties. He had already been carrying on a rental business for over 2 years. A little over a year, I should say, because May 2017 is when we signed our lease. I believe Tom was in July and 100B moved in August. And again, I know that because I helped them get the place. So, let's just do a recap and I'm going to finish this section. We'll go on to the next one. So, rental license. Bylaw says up to 3 stories tall, okay, you must have a license. Must be displayed, cannot be removed, and is not transferable. The license was issued June 19th, 2019, and expires March 31st, 2020. Must be displayed. As of today, June 19th, well, here it said as of September 4th, it was 11 weeks, so it's now, October 4th, so that's another at least 4 weeks, so that's at least 15 weeks that it's not been displayed when it's required to be displayed. And the whole reason for that is they didn't want us to know that they gave it to them yet. Anyway, so June 13th to September 5th, order was written. Sorry, the order was, so it failed, and the order was written. June 13th, until today it's past 80 days, or 90 days probably. No, actually, yeah, 80 plus 30 would be 110 days. So a little over 100 days since June 13th, is it? July 15th to September, until today's date, that's 80 days plus and counting. That's a fail when they were supposed to have it, the order satisfied, and that's the city's supposed to come out, and if it's not satisfied, they're supposed to get people to do it. But they're sitting there saying that we're the ones who initiated this, with all the stuff going on, we're the ones who are preventing them from doing the work. And they concocted a story for landlord-tenant where they just pass the buck between each other and nobody takes responsibility. Anyway, it's very serious what happened next door, and we have to ask ourselves, are you safe? Do you feel safe? I'm not safe. I know we're not safe. We did everything right, and they protect the people who don't. Let's see. May 13th is when I wrote my letter to the landlord. Okay, so May 13th, 2019 to September 15th was 16 weeks and 3 days. Or September 5th. So we're talking, yeah, so add another 4 weeks on that, so it's over 20 weeks since I gave them the notice. May 30th was the fire inspection order, so that was another fail. These are all things that he guaranteed were in the application were fine, and he failed. The other thing, too, it's interesting because they've got 2 different companies going. Company A, they're both the same entity, okay? Basically, Theo Papadopoulos. Company A is 2011987 Ontario, Inc., and that's for 254 Anita Court in Waterloo. And Unit Bs are owned by 2576514 Ontario, Inc., registered under 455 Old Oak Drive. Theo Papadopoulos, Tiemistoklis Papadopoulos, and Eugene Simnos are all partners in these. So in 2011987 Ontario, Inc., it's Tiemi, Theo, and Eugene. And then 2576514 Ontario, Inc. is Theo and Eugene. So Theo Papadopoulos and Eugene Simnos. I assume that Tiemi is probably Theo's dad. Anyway, it doesn't matter. They're all equally responsible. So, I'm getting a little tired here. This has been very stressing, too. They have basically allowed to keep us on the hook, keep us in hypervigilance, play with us at will, circumvent the law. They took all of our civil rights and tenant rights and human rights and sold them to this landlord for privilege. It's definitely not anything like what they're saying in this bylaw. So hopefully you agree. Again, this is for educational purposes and to hopefully gain some support. We need to get this, we're looking to have this order brought into actual court and have them ordered to fulfill it. We're also trying to get help to have it presented properly and have human rights in that help, but they're not, because again, they know what's going on. It's all an obstruction deliberately in order to, and again, what excuse do they have? Anyway, those are other issues, but we're about to be kicked out on the street because we paid our rent. We honored every part of our terms of our contract. All our bills are paid. He honored none of he promised us fenced in backyard, held us up on our gardens for a year and a half. Finally came clean May 2nd of this year. Said we're not going to get anything because he's going to tear the places down. And, so our tenancies don't mean a damn thing. And the city's been helping him to prove that. The province, the region, they just all have their way with us. Because that's what their interpretation of this law is. That's their idea of protecting tenants' rights and human rights. Mayor Jaworsky, you are a liar. Karen Redmond, and again, Mayor Jaworsky is a regional representative as well. So what we believe this is amalgamation. It's a combination of amalgamation of services because, again, they're just not doing it. And how do you explain that? Because, again, what should have happened is just one phone call, come over, here's your checks and balances, you go through your checklist, here's what's right, here's what's not, you fix what's not. Once it's fixed, that is minimum code. That's where it's to be maintained. How much harder is that? Should have been one person, come out, do it, get it done. This should have been done months ago. Not with all this ability to interfere with our private enjoyment, to turn our lives upside down, inside out. We did everything right. We're about to be evicted on the street arbitrarily because they just deny any of the evidence. We gave them full supported corroborated evidence, and there's an outstanding order. The landlord-tenant board actions clearly state if there's an order outstanding, you cannot have an eviction. They could have sat there and made it that he was making assertions. They came totally unprepared. They came with one piece of paper, which was a lie as well, because they didn't. There's a check mark on there that says, "Is there anything we should be made aware of that may change, that may affect this decision?" And they left it blank. So you think that having an outstanding order for, at that time it was August 28th, so that's 30 days ago. So at that time it was almost 60 days overdue. That didn't have a bearing on it. Again, they're just stonewalling us they just rolling us right out. And we get to go out. I get my credit rating destroyed. Denise's credit rating destroyed. There's a housing shortage, so we're going to be on the street. We have to put all of our stuff in storage. We're going to be too busy because the whole point of doing this is then, hey, how do I put stuff on YouTube? I'm going to be too busy trying to survive, right? We get punished. This is highly punitive because we dared to speak out and because we caught them in their inadequacies, because they're so blatant in their arrogance, they don't even care. It's obvious what's going on here. Look what happened, and just because we're distracted. We were distracted by Tom dying. Tom died on July 18th because he had a heart attack, which had contributions from all this stress of this landlord always hassling him every weekend about the dogs, or every month about the dogs, when he's supposed to have a fenced-in backyard. Then he could easily have put the dogs out back had he been honored the agreement. And a tenancy is verbal as well. It's up to the landlord to put the verbal part in writing and provide it to you within a certain time frame. And I'm getting education about this. That's what we all do. But it doesn't matter. We have all the evidence in the world this time, and they still shut us down because it's not withstanding. Anything they're not prepared to deal with, anything they're not prepared to admit. And again, Shane Turner, Mr. Jaworsky, Karen Redmond, Premier Ford. How do you justify any of this? Because again, minimum code is all of our responsibility, but especially the owner. especially if it's a residence and your whole purpose of setting up this residential licensing is to give the impression that there's extra layer of safety there to make sure things are the way they're supposed to be. This is the reality. Stop believing their dream and their lies, because that's all they are. This is a wedge issue that they have definitively made a wedge issue so they could play and exploit off both sides. And they don't care who they hurt. And this has nothing to do with human rights other than to obliterate them and to tell us that if you can't afford to be here, you got to leave. We are at $1,200 a month plus utilities here. We had a 2-year lease. It goes month to month after that. Actually, no, it doesn't go month to month. It goes a year because it's by the term. And the term was a year to year, so that's fine. We did 2 years back to back, but it's a year lease, month to month. And the only way to get us out is if we give notice or they have proper notice. So they were able to bully us out of here, steamroll our rights, tear our whole lives upside down, tear my financial aspect out of it, even though we were the ones who paid everything right. You know, they get to wreak all this havoc, and what does he get? There's no proof he was ever even fined. He gets all this cover. He's been able to torment us along with them for all this time. And now he's got carte blanche to get us kicked out of here and break our lease. So they broke our lease, interfering with our lease, interfering with our due process. They busted our lease. They're going to get us evicted from here. He's going to turn out, he's already got Atlas Property Group. Atlas Property Group. Go look it up online. It's one of those university student housing places that pick the rooms out and rent them for $500-600 a unit. So what? He's going to turn this back into 6 units at $600 a month? That's $3,600. That means he's going to triple his rent. He's going to triple his income because they helped him break our lease. And we get thrown out on the street, but hey, at least we got services, right? And you guys get to go check mark on your little box about how many services you've been able to provide. This is notwithstanding, and I'm not standing with it anymore. I'm not standing for it anymore. As I said, I'm done. And they did this before in 2014, up the street. Exactly the same thing. You try and get a hold of them. We asked for assistance through AOTA. They dropped the whole thing. There is no accessibility for anyone. They called it a legal issue, which says that they don't have to deal with you and you have to go hire a lawyer, and the only lawyer you can hire if you're low income is legal aid. And even if you have an income, they all work for Law Society of Upper Canada. That's why you could hire a lawyer too, and all they do is spin your wheels and grease their palms while they bleed you dry. The real issue is this: if anybody was upholding the law, we wouldn't be having any of these discussions. They sit there, they go, there's a law here to protect you. Well, let's go to court and argue about whether or not you're protected. Really? I'm sorry. Mr. Trudeau and all the rest of you politicians, again, shame on you. This is the biggest human rights case, and I don't care if they throw me out on the street. I fully expect that they're going to shoot me, because that's what they're going for. Again, we have asked for intervention with liaison services, and they keep showing up just intimidating because they don't have to follow the law. It's called rule of the law. And where do rulers come from again? The crown. You need to wake up. This is the reality of what they're doing with the law, with the taxpayers' funds. And every single, again, there's law-abiding landlords out there. There's law-abiding property management companies out there that call Becker Fire Services. This company has been provided a predatory plateau to be able to predate on the helpless, the ones who can't defend themselves. And it's funny, it's the ones that go through tribunal that are not a court. So again, with the weight of evidence, this says you're not allowed to lie or misrepresent. We have proven more than enough that he has. So again, I'm sorry. This is really difficult with my PTSD, but that's exactly why they're doing that. So I'm going to call this one quits for now. And, you know, help us, help yourselves, help justice, help human rights. Because like I said, if it comes to it, I will remove all of our stuff, because we have a lot of stuff, as you can check. Here, I'm going to show you. We are not just flunkies. I have thousands of dollars in equipment, which I have built up over years. Denise, you know, we have lives here. And that does not give them the right to do what they're doing, because, again, we've already lost property because of them doing this stuff. And who's required to hold minimum standard? They're not even upholding their own laws. Here is a prime example. There is only one way to handle this. We need to get this stopped. We need to have an injunction. We need to have them ordered to fulfill this order. We need to have our rights preserved. And we need to stop this landlord just because he's a developer. And this is the second licensed real estate agent in a row. We were in Kitchener for several years, on Cortland, and only to find out that that unit that was proffered by a real estate agent was, again, a fraudulent thing. And let me just show you. This is the actual license that was hanging up when we came to see the place. Here's a copy of it. We got it. You see? March 2nd, 2017 until March 31st, 2018. It's made out to Jose Chavez. Actually, I'm going to go turn it the other way. Sorry. Here it is. This is the one that was hanging up in our corner of the conspicuous place of the unit when we actually looked at it 2017. It looked like it was legit. Date issued March 2nd, 2017. License 2017005416, 100 Marshall Street, A, Waterloo, Class D, Class 2, Unit A. Owner name and address, Jose Chavez, 36 Mill Creek Road, Cambridge, Ontario, which says unequivocally this was not owner occupied. Again, issued by Shane Turner. This is the license that was hanging up when we saw the place. This is the business card that Theo Papadopoulos gave us when he negotiated this contract. As you can see, it says Kupel Marcu, Theo Papadopoulos, Sales Representative, Commercial Real Estate, Inc., brokerage. And again, this is a rental property, so it's automatically, when he hands you a copy of a card like this, you automatically assume, well, he's with Kupel Marcu. No matter who he tells you to make the checks out to. Commissions Worldwide, Inc., because he's a commercial broker, which means he does residential commercial properties or whatever. If a landlord owns it and puts it out for rent, that's not commercial property, who knows? But anyway, doesn't matter. This is the card that he gave us. Nowhere on this card does it say CWW Inc. at whatever his address is. This is a real estate agent that proffered. He bought the property on May 1st. He leased it on May 5th. Did no due diligence, conned us, and is fully supported by the city and government. And the law, because he paid for the privilege, apparently. He has a development deal in with them, as did the last real estate agent. She's the one who owns all the property where Barrack Castle's going up and around that neighborhood. Several instances. This isn't the only place. We could show the pattern of behavior that has emerged, because you can go, it doesn't matter which government's in power. You know, this is an agenda that they are putting forward. And in Kitchener-Waterloo, there is a cabal that makes sure that anything to do with breaking the law by anybody in Kitchener-Waterloo is covered. Such as when I was assaulted at the courthouse, I was brought into Grand River Hospital, and not one person gave me an actual physical exam for the damage that I sustained during that arrest. I was held without contact for over 7 days, without seeing a lawyer, without having any kind of hearing, with a power of attorney in force that they ignored, no access to any kind of hearing at all, was brought out to Wellington Detention Center, did not see a lawyer until I was brought into Waterloo County or Waterloo Region Courthouse almost 10 days later. I saw my daughter at the jailhouse before I saw my lawyer, and my lawyer did not defend me at all. 9 months of just covering up, because again, if he had defended me, the first thing he would have done was changed venue. It's Waterloo Regional is the one who did this to me. Regional Waterloo Courthouse. The officers at the front desk that assaulted me were Waterloo Regional Police. This is Waterloo Region. Anyway, I'm done. I'm done. I am not letting them do this to me anymore, and all because I walked into an employer. Again, here's this theme. An employer operating illegally for 5 years, unlawfully for 5 years, doubling the accident rate with not having any kind of health and safety policy until a year after my accident, and with Labor Board and WSIB going in to investigate any accident every time. And they didn't see that there either, just like they don't see this. Wake up, people. Law Society of Upper Canada, it's not withstanding. It's time to return the favor. And Mr. Trudeau and whoever else, like I said, everything to do with security of person enshrined in this Charter of Rights and Freedoms, education. Anyway, I'm too tired. I wrote it down. It's there. Everything to do with anything to do with security of person is run by quasi-judicial tribunal, not the courts. That is not freedom. That is the rule of law. The fact of the matter is, we abide by the law. The Crown rules the law. Time to wake up. Anyway, I gotta let this go. Thank you. I'm gonna put something else together to just to finish this off. Anyway. Yeah, you need to know where this is going. There's one more venue to this, which is actually, I got in touch with the building inspector for the City of Waterloo, and we had a really interesting conversation. He was coming out here to do an inspection, and there's just one more vignette to this, and I hope you bear with us. After that, I will be putting, actually on the end of this, will be the actual recording of the call, the initial contact between myself and Shamir Maida, City of Waterloo from December 29th, from May 28th to 29th of this year. I believe it was the 29th, which was the day before the inspection, the first fake inspection. I think it's self-explanatory, so it's about a 30-minute phone call, I think. Hopefully you can bear with it, but it's very worthwhile to hear the end of it, to hear it to the end, because it's very revealing, and I'm going to put part of the transcript out there as well for what we found out, but he actually admits that they don't ever do an inspection, and that even with the order here, it's not necessarily a requirement in order to give them the order from the way they talk about it. So again, the dichotomy between what they say in practice and what the actual bylaw is should be enough to bring to council and to raise these issues. So we're hoping you'll join with us, and we will talk to you soon.